Shit is so wrong on so many levels.
And I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the
The
floor and
the
put them in front
judge
of him.
keep
And Rick,
muting that boy
I'm
ass.
not presenting to nothing
She
else
gonna mute him
about the
again.
case,
Watch,
but you
y'all.
can't deny me the right to put on the okay? How
That's
can you tell
fucked
me
up.
when I'm out of state?
I'm gonna read it once again because
She
again,
muting
I
him
understand
again,
he's
y'all.
upset. If
They have nah, fuck that. They got the officer to come in and grab the papers that they put in the officers put them papers in that garbage. Now they got the officers coming back in the camera, making sure the garbage is in the camera view to see to show the camera. Oh look, y'all see the camera? Y'all see the garbage? The papers was in the garbage that he threw in the garbage. He didn't throw them papers in the garbage. That judge made that sheriff come go and put them papers in that garbage and take them papers out of that garbage in front of that camera like that to make this man look bad. You are not allowed to mute anyone unless they're using provocative and vulgar language in a court setting. This man is trying to defend his rights, and he's trying to appropriate exhibits to show you evidence to prove his innocence, and you guys are muting him. Y'all doing all this fucking racist stuff. That's not right, dog.
well, he put him on top, he put him on the floor.
That's not right.
That's his
bro.
right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue.
Nah, ain't no
to
for the
debate with
record.
this
You are
court
being a
about
wrong, a
what
disrespectful
rulings
judge.
regarding his
You're provoking a black man's
forfeiture
feelings.
by
That's
conduct
what you're
of his right
doing.
to present further evidence
No,
on his
you're
behalf.
provoking a black man's feelings and emotions. That's what you're doing. That's what she's doing right now.
I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the.
That's not right, bro. That's not right, bro. I don't know if he really killed 9 people, but that's not right for them to at least like mute him like this. Like, it's no matter. Like, that ain't right, bro.
Um, 76. The 76 count. Just want to make. It says near.
Everything he studied. That's all his law work right there, y'all. So y'all trying to tell me this man don't know what he doing? That's all his law work.
So,
This lady keep muting him.
As it relates to the jury instructions.
I'm just going through each one. I'm on page 50.
This is not supposed to be personal. This is for a man's innocence. This man is trying to fight for his innocence. And you talking about you understand him being angry or upset. You need to understand that he's trying to fight for his innocence. Fuck being upset. This is what's wrong with the white man's system. They too busy trying to understand our emotions and feelings instead of understanding what the fucking real problem is. Look at her, bro. She knows she wrong. Racist ass man. Racist ass lady. Racist ass sheriff.
Is requesting to go back to his cell at this point. I'm going to deny that request. He can remain in the other courtroom.
They messing with that man emotions right now. This how the white people are doing this racist shit. Look at them now. Look at this shit. This is why Waukesha was hit with that Hurricane Ian so hard. Now, bitch, they doing some racist ass shit up there in Waukesha. Whatever the fuck that is. Every time this man tried to defend his side, his piece, that lady got them muting him. I ain't gotta worry about me doing nothing illegal, cause I'm good. I do everything legal in my life. Ain't gotta worry about me looking at no judge. Them muting me and doing all this crazy shit. That's how they want us to act out here. That's why they put all this fentanyl out here so we could be acting just like this here, y'all. He ain't filed now Form 56, Judiciary Form.
I know he's muted, but
He ain't filed no Form 2885. Ending all he supposed to file a Form 56, Form 56 Judiciary, ending all judiciary relationships with anybody, meaning the judge can't have jurisdictions over him. Now he supposed to file the goddamn Form 2885 to give himself power of attorney, and then he was supposed to go in that bitch like that. He just go in that bitch like just butt naked than a motherfucker. He do his law work, cause if he would have did his law work, he would have filed the damn that 2885 form, power of attorney form. Then he would have fucking filed the Judiciary 56 form. If we gotta play their game, we gotta play the game how they play it, bro. We can't have step, none of that shit. If you know you gonna kill bitches and then you gonna turn around and represent yourself as in court, you gotta know the whole motherfucking thing, bitch. You gotta know what forms to file. Bitch, you can't just represent yourself in court and think them folks gonna respect your ass, and you ain't filed no forms out here. You ain't filed no form Judiciary 56. You ain't filed no power of attorney form 2885. But you just went and got accused of a whole goddamn execution, 9 people, and you trying to represent yourself in court. Of course they gonna have a field day with you, gang, cause you ain't operating the right way, bro. You not operating the right way. You out here half stepping. You not stepping for real. You half stepping. Motherfuckers understand what I got the forms. I got them same forms I'm talking about. Bitch, I don't cap what? I got them same forms. Hold on, let me show y'all. Y'all think this shit a game, bitch. They better get their mind right out here, boy. Y'all that be doing this fried shit and don't understand, boy, how to operate out here, boy. Y'all that tripping. Shit, them folks find my ass. I got a form. If them folks give me a traffic ticket, boy, I got a form where I ask the governor for forgiveness, nigga. Fuck you talking about? Boy, I ain't playing. 2885. Playing all fines are dismissed type shit. I got a form that goddamn tell me this, all fines are released. Stop playing, y'all better get y'all mind out the motherfucking hood, bitch. Just cause y'all live in the hood don't mean y'all mind gotta be from the hood. Y'all gotta get y'all mind somewhere that's gonna be elevated. Somewhere that's you gonna know this type of shit before you go into situations like this. Not saying it's good to kill people and then go file the forms and power of attorney forms so you could be able to represent yourself in court and get off. I'm just saying he ain't taking the right steps, and then he in court trying to use masculine energy towards a judge. He not gonna win like that. You not gonna win like that because she still got power over you. She could mute you whenever the fuck she want because she got judiciary power over you, nigga. She got judiciary goddamn jurisdiction over you. Once you file that goddamn Form 56, bitch, she can't do none of that mute shit, none of that dumbass shit she doing, boy. All that muting me, all that dumbass shit, boy, she is violating your rights. The fuck? And then he can't even say that she violate his rights because really they his guardians. He in their custody. So whatever they do to him, to the higher ups, they telling the higher ups it's for the best interest. He's being out of control. He's being obnoxious. With that, once you file that Form 56 judiciary, them motherfuckers can't say none of that, bitch, cause you walking on your own feet. You your 10 toes down for real, bitch. Who? You can't tell me that I'm mad right now. You can't tell me that you understand that I'm angry right now because this isn't what this is about. I'm here to fight this case and defend my innocence. So when you're involving emotions and feelings in between a case that I am trying to prove my innocence, yeah, I would have hit her ass with all that shit. Boy, she would have knew she was in violation. I filed Form 56 fiduciary. So that means no county nor judge municipalities or whatever the fuck they say. Nothing, no municipalities have jurisdiction over me. Feel me? I'm my own power of attorney. Fuck is you saying? The fuck? You can't talk to me like the motherfucking person that committed the crime because I ain't the person that committed the crime. That's the straw man that committed the crime. Y'all trying to attack my straw man. You feel me? But me representing myself as my power of attorney, bitch, y'all can't come at me like I'm the straw man. I'm the power of attorney. And here's my Form 56 fiduciary, ending all relationships with all goddamn people, trustees, anything, all that shit like that. I ended that shit. Nigga, fuck wrong with y'all. Motherfuckers don't got nobody around them that's gonna give them that knowledge. All the niggas, all the goddamn dumb down the whole fucking family. Dumb down the whole fucking family, dude. You telling what happened in his ass. Ain't no telling what happened to his ass. Make him go out like that. Damn. You just took everybody out, bro. Damn. That nigga took everybody out, bro. That nigga fried.
What's the state doing on its review? Okay.
I'm still looking for my video.
just want to make a continuing record that Mr. Brooks is still here, and even though he's due to his level tone, his voice and volume level that he is using from the neighboring courtroom. I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
Wow, got that bitch, y'all. Woo, that bitch took a long time. Find that bitch. Alright. Now, Mr. Brooks was supposed to file this form. This form. And when he in court defending his innocence, he's supposed to file this form.
I know upon my review, I noted a few spots that either in the headings.
If he in there representing himself and he ain't filed this form,
but why don't you go through and tell me?
this is why they're treating him the way they treating him.
We'll go page by page and just tell me what page number and what section.
See, when we don't have the intellect or the knowledge to look into things, we see our people being taken advantage of, like we're witnessing Darrel Brooks being taken advantage of.
The specific case number. So when we first talking about,
when you see the severity of how unfair these people are,
we start talking about the bail jumping.
why would you want to do crime? Why would you want to do mass shootings and go out there and kill people, man? These people is trying to put y'all ass away. The nigga faces 5 life sentences, and then the judge added one more because they said the 6th person that he killed, he shot, they died. So they trying to get that nigga 6 life sentences. But they don't got no I ain't never seen no video of the man shooting. But I heard about the hurricane that hit Waukesha. I ain't never seen the parade shooting.
And then just because I think this was just well, I guess
it's one-sided.
When we look at the verdict forms on page 102 to 107,
it's one-sided.
There's verdicts for the bail jumpings for 3 separate counts: 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
See, they overdoing it. They're not giving him a fair trial. This is not a fair trial. Look at how the damn people just called out that error. And then the judge gonna say, oh, that's correct. You should have known that in the first place. What is you doing? This how they play with the black man that don't file this. This is how they play with you. And then you have to hope that good Samaritans like that woman who just spoke and pointed out an error. There isn't supposed to be any bad allegations on Mr. Darrel Brooks on 76. It's only supposed to be the battery.
Just acting up a bit, so.
Yeah. Yeah. Get y'all shit together, Judge. This isn't a fair trial.
I guess what the changes are requested. I'm gonna make some notes and then we'll go through one by one. So,
and I don't believe it was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended.
Again, another wrong error.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
They trying to construe the verdict. They trying to construe the trial, y'all. They putting shit in wrong areas. What is going on? If you will stop muting the defendant.
Yeah, and then
stop muting the defendant. Maybe we could put something that's supposed to be there.
107.
Fuck is y'all talking about?
76, which details it as a bail jumping. I believe that should be the battery.
Bitch ass judge, boy.
I did notice
I don't know what the fuck I'm talking about. I'm just talking shit.
the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was.
I think that's part of the pattern instruction.
Oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
We'll look at that. We can look at that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se.
Municipalities.
There's a standard paragraph, which is the first paragraph
Municipalities.
listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
Look, the judge is trying to highlight the defendant's behavior, not his defense. They're paying attention to his behavior, his body languages. They're not really hearing his defense. That's not fair.
Okay, with regard to page 106.
Fine.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute? That refers to the double.
Right, sir, I'm not gonna have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with them.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed. What other requests do you have, sir?
Don't talk over me. Don't talk over me. Just like you don't want me to talk over you.
Look, they just removed the man from court.
Mr. Brooks, what other requests do you have?
And I just asked you not to talk over me.
Which she is doing.
You've been making your record the whole time you've been over there. You haven't muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I let you do what you was doing.
Right. This is an unfair trial, bro.
You both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has
But you
any
denied
other
every
requests.
fucking thing he's saying.
If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here's your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit in here and try to play those games talking about you giving somebody an opportunity. Because Riley gave me an opportunity to properly defend myself with evidence, with substance evidence, which I've asked you repeatedly to do before we even got to this trial. You told me you wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, all right? Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yeah.
Oh.
That first count 74 bill jumping, he just did. You can't charge him with two things. You can't charge him with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one company gonna charge you with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was gonna deal with. The same exact thing, the same exact case. So why are we giving the jury instructions on two cases from another county?
I've made a note of that. What other requests do you have?
Okay, finally, she says she made a note.
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything. Because everything I say is going to be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks.
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Finally.
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talking big game. You talking big game to say yourself is unsafe. But everything I put together has no merit in your court. None.
Right, I've asked him
Which is true.
many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent.
All right, he did not answer. So I'm muting him again. The only request that he has
Violation of
made
his rights
as it
again.
relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision.
You can't, as a judge, understand frustration.
Was made
He's fighting,
based on
and
his
you are
conduct
fucking
and his
pausing him,
conduct
muting
alone,
him.
as
You're
I've outlined
frustrating
already
him
on
on
the
purpose.
record. So
For
the
the
only
record,
request
bitch,
that
this
he
judge
made,
is an ass judge.
was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through
Like
the
you denied
states.
everything.
Sure.
I'm sorry, 154 summary.
They say
of
you got to
evidence.
deny one more
I
thing.
believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his routes, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case, I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm gonna just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting here, thank you, I'm putting here. Well,
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner.
Lies. They finna get that boy 6 life sentences, boy. Damn.
Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. It should read, evidence has been received.
Bro, they put a fucking bougie ass judge on this man's case.
Convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense.
I don't know what happened.
I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last.
He can't hear you.
Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106, because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir? You have been.
Am I unmuted?
You are.
So how long before you leave? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsible to what you guys are doing? That did not say you even have it at this point. So what's the point of me being responsible? You can't make decisions for me.
Mr. Brooks, I'm gonna mute you unless you can participate in what we're doing, which is discussing the jury instructions.
Disgusting.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them
If
what
she
happened
mute
to
him,
those
she
things.
violating.
I haven't been able
Mr.
to
Brooks, I'm gonna mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment.
Went to sleep, woke up flex. Bitch got X, came from S. Brand new piece, sleep like Texas.
When marine biologist Christine Figener filmed her colleagues pulling a plastic straw from the nose of a giant sea turtle off.
Damn, dog, that's crazy, dog.
Chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented? Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that was exhibit 141.
But that was received, wasn't it?
And there were some.
Do you know about the exhibit list, ma'am? What are those numbers again? I wrote 141.
Just looking for the extreme dance and dancing granny charts.
This is 54.
54 would be the dancing grannies,
Okay.
and 33 is the extreme dance team.
So 54, 141, and 33.
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
they were all admitted based upon how they were presented and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 52 regarding the view.
And as I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions.
That was my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions? He's not responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir. I understand, sir, your objections noted. Your lack of consent is noted.
Okay, I don't see what's going on in this. So how is decisions being made without we being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break, so let's make sure the record is correct. You took a 10-minute break,
I did.
at which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even during this time though, you've been incredibly disruptive
I can't tell you.
At one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm gonna be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no. How do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it. You can't just say, I'm gonna do this because.
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings. You the one that held me in contempt.
I never held you in contempt. Alright, I'm gonna mute him once again because he refuses to answer a very simple question about whether
That's what
he has
you
any
keep doing.
requests
You're holding
as it
him in
relates to the
contempt
jury
by muting
instructions.
him.
I will work on making all the changes with
That's
Madam
crazy.
Clerk, finalizing the order, print them off again. She has
must
been
be
working
came
on
off
the
a beauty
verdict forms,
pageant
which are of
straight
course
into law.
separate, which need to be approved by this court. So those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break, so it's 11:27.
Me some food.
So we'll come back
Saltfish and
at
Yankee.
1 o'clock
Callaloo, man.
to finalize the verdicts
That's
and
crazy.
the jury instructions.
In your honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay.
We can do that.
Thank you.
Okay, I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form, so all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be
They
deliberating.
trying to get that boy
But we
life,
can make
6
a more
life.
full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock.
Alright, that's
Just
it, folks.
instructing the parties to stay until the handout of the verdict, and then you can leave for lunch.